Good evening. I'll now call the planning board meeting to order. We'll have our roll call now. When your name is called, please say here or indicate your presence by raising your hand. William Roach.
Here.
Joe Towns.
Here.
Tamara Lipscomb. Here. Thomas Thompson.
Here.
James Motley.
Here.
Kia Mills. Here. Charles Fay.
Here.
Okay. Can we get adoption of the agenda for July 15th, 2026? Can I get a motion?
Second.
It's been moved and second that we adopt the agenda for July 15th. All in favor?
Aye.
Okay. No opposers. Approval of the minutes from April 15th, 2026. Can I entertain a motion?
Motion to approve. Second.
All right. It's been moved and second. All in favor? Right hand. Opposers have the same one. All right, we'll go into our items for consideration. Consideration of a rezoning request for the property located on Willow Street, parcel number 154-196Z1. The owner and also the applicant of this property is BMS Investment Properties, LLC. The owner and applicant have submitted a petition to rezone this mixed undeveloped property from residential agricultural 20, RA20, and residential 20, R20, to residential 20. Docket number Z2026-04. Hi, Claudia.
Hi, good afternoon. BMS Investment Properties LLC is the owner and applicant of the undeveloped property located at Willow Street, parcel number 154-196Z1. Has submitted a petition to rezone the parcel. The property currently contains two zoning designations: residential agricultural 20, RA20, and residential 20, R20. The applicant is requesting to rezone the entire parcel to residential 20, R20, one of the property's existing zoning classifications, to establish a single consistent zoning designation across the site. This parcel is subject to the approval of the annexation request by City Council. The parcel encompasses the total area of 6.251 acres. Water service is available within 47 feet of the right-of-way of Willow Street. This water line is operated by the City of Reidsville. Sewer service is existing or available within 39 feet of the right-of-way of Willow Street. The sewer line is also operated by the City of Reidsville. Due to the elevation, might be some challenges connecting sewer from some parts of this property. The property is not located in the Jordan Lake watershed or Troublesome Creek watershed. There is one stream on site, a 4-foot creek. The floodplain insurance rate map indicates no floodplains. This rezoning proposal is in alignment with our watershed regulations and does not pose a threat to the watershed or city's drinking water supply. This property is located in Growth Management Area 4. This growth management area is rural, which is mainly characterized by residential development and undisturbed and natural areas. These areas are generally located adjacent to existing urban areas and municipal services, and the current road network is capable of accommodating future growth. The staff finds the proposed rezoning to be consistent with the Reidsville Land Development Plan reasonable and in the public interest based on the above-mentioned information provided in this report and the attached statements of the reasonableness and consistency. The planning staff recommends the proposed rezoning application to be approved. And the applicant is, one of the applicant representatives is here. If you have any questions, he can come to the podium.
Thank you. Are there, excuse me, any questions for Claudia? Not, we'll hear from the applicant. Thank you. Okay. At this time, is there anyone to speak for the consideration? If so, please come forward and state your name and your address.
Alex Carter, 4510 Reidsville Road, Winston-Salem, North Carolina, 27101. Here to represent BMS Investment Properties. Don't have anything further to add to the presentation. It was very thorough, but here to answer any questions you may have.
Any questions? Okay. Thank you, sir. Is there anyone here to speak against this consideration? If not, hearing none, we will close the public comments and go to board discussion. Any discussion, board? Any questions? All right. Hearing none, can I entertain a motion to consider the rezoning request?
I make a motion to recommend the proposed rezoning to be approved for the specified parcels to the requested zoning district based upon consistency and reasonableness determination. Statements that are included in the council agenda packet submitted during the rezoning presentation, and as may be amended, incorporated into the motion to be included in the minutes.
Second.
All right, it has been moved and second. Any discussion? Hearing none, all in favor?
Yeah.
Opposed, have the same sign. No oppositions. All right. And the motion is carried. Thank you. Our next item for consideration. Consideration of a rezoning request for the property located on 814 Lindsay Street, parcel number 154288. The owner of this property is Stephen Curry, and the applicant is Marlene Harrison. The applicant have submitted a petition to rezone this developed parcel from residential 6 to general business, docket number Z2026-05. Thank you, Connie.
Thank you. Marlene Harrison has submitted a petition to rezone the entire developed property located at 814 Lindsay Street, parcel number 154288, from Reidsville R6, from residential R6 to general business. The owner of this property is Stephen Curry. The parcel encompasses a total area of 0.31 acres. The land is currently zoned residential 6R6. Water service is available within 34 feet of right-of-way of Lindsay Street. This water line is operated by the City of Reidsville. Sewer service is existing or available within 34 feet of the right-of-way of Lindsay Street. This sewer line is also operated by the City of Reidsville. The property is located in the Jordan Lake watershed and Troublesome. It's not located, in the Jordan Lake watershed or Troublesome Creek watershed, and there is no stream on site. The floodplain insurance rate map indicates no floodplains. This rezoning proposal is in alignment with our watershed regulations and does not pose a threat to the watershed or the city's drinking water supply. This property is located in Growth Management 3, which is suburban, and is mainly characterized by residential where locations of commercial, industrial, and office employment can be found. The existing residential areas are stable, and the existing roads are unable to accommodate much growth. The property is located along a commercial corridor near existing businesses, and municipal services are already available. Therefore, commercial development can occur in an orderly manner. Staff finds the proposed rezoning to be consistent with the Reidsville Land Development Plan, reasonable and in the public interest based on the above mentioned information provided in this report and the attached statements of reasonableness and consistency. The planning staff recommends the proposed rezoning application to be approved. And the applicant is here as well if you have any questions regarding this application.
Thank you, Claudia. Any questions for Claudia before we call the applicant? Okay, thank you. All right, at this time, anyone here to speak for this consideration? Applicant, please come forward and state your name and your address.
Hello, Marlene Harrison, 4181 NC Highway 14 in Reidsville.
Good evening, Ms. Harrison.
Right now, it's operated as a family care home, which consists of a small assisted living. We've been running, it's been in assisted living for over like 20-some years. We took over it in 2019. And right now, we are wanting to rezone it for commercial because we're wanting to close down the family care home and open up in PSR, which is Psychosocial Rehabilitation Center. That is operated during the day, usually from like 9 to 3, and it's a mental health and substance abuse program. So it's for anyone, mental health, substance abuse, it's for the community, people that may be in assisted living family care homes, people who may be coming out of prison, homeless, people that's just having a rough time making it and don't have resources and don't know really where to find resources. In this area, it's not a lot of times that people have to go out of the Reidsville to get help. So we're just trying to bring something into the community to help local residents where they won't feel like they have to go to Greensboro, Charlotte.
You said hours would be like 9 to 3?
Yes. We also, part of that is also peer support, which means if they do, they also can get assistance when they leave the program. So if they're at home, then they have a sponsor, which is a peer support specialist that helps them navigate life while they're at home. If they are in a facility or something and they need help with that, then that person also is a contact person for them. We also would offer therapy sessions out of there. It's a 24-hour crisis number, so if they're having, at any time, they have someone available for them. So also we are helping run one that just came into the community on 2311 Freeway Drive called Enhancing the Quality of Life. So we just started that one. The lady that has been mentoring me out of Charlotte, she's been running hers out of there for like 5 years. So she started mentoring me, and I asked her if she could come this way while we're trying to get everything going. So that one has already been operating. We're at full capacity there, so that's why we're looking to get this building so that we can help more people.
This will be your second location?
Yes.
Thank you. Any questions for Ms. Harris?
I do have a question. What do you anticipate the capacity of this new facility being?
When the building inspectors came to look at everything, I think they said like 49.
49.
We could have no more than 49. But with the rooms, the size, and the three full bathrooms, which we wouldn't use, the tubs and stuff. But with the 3 full bathrooms, he said that it could be around like 49. It also has 1, 2, 3, 4 entranceways and 2 ramps onto it.
Thank you.
But it's not somewhere people would be staying over. I mean,
No, they wouldn't stay. That's what we're doing now. They live there now. where they were. We moved the residents to one of our other homes so that we could see about getting zoning.
I do have an additional question. As you were speaking, I understand that the people who will be serviced are people who have other residences. They're either in homes or some other kind of facility. They simply need the services that you can provide. And this is just them coming, getting the services, and leaving at the end of the day. Is that correct?
Yes, they can be in a home like assisted living, or they can't be in a nursing home, but they can be in assisted living or family care home, or they can be in their own individual residence.
Okay.
Other questions? All right. Thank you, Ms. Harris.
Thank you.
Thank you. Anyone else here to speak for the consideration request or rezoning request? If not, if there anyone here to speak against it? Hearing none, we will close the public comments and go to board discussion.
It's something that's needed for the community.
Absolutely. And that's needed.
For the community. Yes, I agree. It's needed.
Absolutely.
It's needed, yes.
Well, with that, can I get a motion?
Madam Chairman, I make a motion to recommend the proposed rezoning be approved for the specified parcels to the requested zoning district based upon the consistency and reasonableness determination statements that are included in the council agenda packet submitted during the rezoning presentation and as may be amended, incorporated into the motion to be included in the minutes.
Okay.
All right, it's been moved and second 2 times. Any further discussion? Any discussion? If not, we'll go ahead and move for a vote. All right, all in favor, raise your right hand. All right, opposers? No opposers? All right, and the consideration of rezoning request has been. Thank you. Good luck to you, Ms. Harrison. You're welcome. All right. This time, can we have the planning staff report?
Thank you, Madam Chair and other members of the Planning Board. We don't have a whole lot to relay to you tonight. We haven't had Planning Board in a few months, so we really haven't had a lot that's gone to Council. Just to give you some updates on some of the initiatives and things that are ongoing that the planning staff have been involved in, I gave management team an update similar to this morning. First and foremost, we're moving forward with working on the dock policy and the recreational items for consideration by the board and by ultimately council later on for recreational initiatives and things at Lake Hunt. We did have our Lake Hunt event this past weekend. If you were able to attend or if you've heard any news about it in the community, it went really well. We had about 100, give or take a little bit, participants who came out and saw the lake, people who came from as far as Burlington, Alamance County, Winston-Salem, Brown Summit, because they're really looking forward to what we're going to do out there with the swimming and everything. In other news, not technically related to your board, but I've been telling everybody, we did have a small incident with the Governor Reed House where there was some damage due to water. We're working to fix that. If at any point you would like an update or if you'd like to see the damage that's occurred, just contact me or my staff and we can let you in to see it. We're moving forward working with After Disaster and some other contractors to get some quotes and get that cleaned up. But it was a pretty significant portion of water damage in the addition room. So thankfully not the original structure, but the addition that was on the first floor that does not have a second floor located above it. So other than that, we really haven't had any significant zoning permits that have really been issued. A couple here and there for some small businesses. I think you saw the Reaper store open downtown and we're super excited for that ribbon cutting that's coming up. But most of it's just been renovations, decks, accessory structures, things of that nature. We will potentially have some stuff going to TRC soon for some small commercial additions and other things, or perhaps in review currently. But we don't have comments back from TRC at this time.
Good. Thank you, Drew.
You're very welcome. Any questions?
Any
for me?
questions?
Drew,
Yeah.
saw this on Facebook last night. The brick facade at the old Reidsville grocery, could you tell us what's happening there?
I can tell you what I know. It's a little bit outside of my realm. I do believe the inspectors are tackling that one head on. Sometime as of over the weekend, Saturday or Sunday, that building did begin to collapse. It's just an old structure that was in a state of disrepair. To my knowledge, the inspectors are working with the property owner to get that demolished. That's all I know so far. It is actually the structural integrity of the building that's been compromised, not just the facade as we saw with 105 Gilmer previously. It is the structural integrity of the building.
Do we have a lot of those in downtown at this time that are in danger?
I couldn't speak to that based on the, analysis that my staff has done and the code enforcement staff with reaching out to the different property owners. Our complaints are all pertaining to zoning and land use. We haven't done any sort of evaluation as to whether the buildings throughout downtown are in a condition that would constitute disrepair or condemnation.
Anything else for Drew?
Thank you.
Drew. Thank you.
Yes, ma'am.
Moving on along our agenda, planning board member comments. Any comments from the board?
No, I don't think so.
Hearing none, may I get a motion to adjourn the planning board meeting?
Motion to adjourn.
Any discussion? Okay. All in, yes, Ms. Mills. All in favor?
Aye.
All right. Planning board meeting adjourned. You see, we're going into our board of adjustment meeting. Okay. It is 6:22. We are calling the Board of Adjustment meeting to order. Roll call, we've already established roll call. Everybody is here. Adoption of the agenda for July 15th, 2026. Can I get a motion?
So moved.
All right, it's been moved and second. All in favor? All right, the agenda has been adopted. Items for consideration. Consideration of an appeal of administrative decision regarding the issuance of 2 notices of violation for unpermitted clear-cutting activity and the removal of a required tree buffer by property owner GHM Investments, LLC. Parcel 1 is located along Freeway Drive, Rockingham County, parcel number 186700. Parcel 2 is located along Pecan Road, Rockingham County, parcel number 186699, docket number AP 2026-01. At this time, I'm going to call Attorney Tim Wyatt.
Yeah.
Okay.
Okay,
Do they need to be sworn in? Attorneys do not.
Okay, board, this is a quasi-judicial evidentiary hearing that you've got tonight per North Carolina General Statute 160D-406. It sets forth the state standards for rendering a decision as follows. The board's discretion is limited. The board must base its decision tonight upon competent, relevant, and substantial evidence submitted into the record. The board's decision is constrained by the standards identified in the zoning ordinance and based on the facts presented during the public hearing. If you will be speaking as a witness, please focus on the facts and standards, not personal preferences or opinion. Participation is limited. This meeting is open to the public. Everyone is welcome to watch. Parties with standing have rights to participate fully. Parties may present non-repetitive evidence, call witnesses, and make legal arguments. Parties with standing are limited to the applicant or the appellant party and their legal representation, the local government, and individuals who can show that they will suffer special damages as adjoining property owners. General witness testimony is limited to facts, not opinions. For certain topics, the board shall need to hear opinion testimony from expert witnesses. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they will base their expert opinion. Witnesses must swear or affirm their testimony. Staff shall administer the oath for all individuals who intend to provide witness testimony before they address the board. Dialogue between the appellant party and City of Reidsville staff is not permitted. All commentary and questions from either side and witnesses should be directed to the board. Comments which attack the personal character of any presenter, individual witness, staff member, or board member are prohibited. Furthermore, statements intended to disrupt the board's consideration of presented materials or intended to incite conflict between those identified herein are not allowed. The appellant party has the right to present its own evidence and make objections to the evidence presented by staff. It is the responsibility of the chairperson to call and hear all objections. Should an objection be made, the chairperson may provide the opposing party with an opportunity for explanation before rendering their decision to sustain or overrule the objection. If an objection is overruled, the objecting party may request that the board consider the objection as a group and subsequently vote on whether the objection shall be upheld. Should this occur, a motion and second by the board shall be necessary and a majority vote rendered for approval. At this time, all sitting board members are asked to disclose any ex parte communication that you may have had prior to this meeting, preconceived biases, or other relevant conflicts of interest or ethical dilemmas that would render your participation in tonight's hearing a violation of statute. The City of Reidsville Planning and Community Development Director, Drew Bigelow, under our ordinary procedures, we now receive the oath and present staff's opening statement. I understand that the appellant has a couple of pre-hearing motions that they want to hear first.
We do. Mr. Martin's going to pass out some materials.
Of course.
We only have 6. We didn't realize it was 7 here in the board.
No, I have a copy. Was there an extra affidavit?
Do you need one?
If we do, I was going to give Tim, Mr. White, a copy. Yep, what's up?
Good evening, everybody.
Good evening.
Sorry to bombard you with a lot of documents, but I think that will help everybody as we go through discussions tonight and go through this hearing. So the first thing, I want to make a motion. I'm going to make a few pre-hearing motions before we get into the substance of the city's evidence. The first motion I'm going to make is a motion of recusal and a motion to recuse Mr. Charles Fagg from participating and voting in tonight's session. One of the fundamental rights to these hearings, to a quasi-judicial hearing, is fair and impartial decision-making. Part of the affidavits that I handed up of Mr. William Martin and Mr. Donald Powell, you'll see the last two statements in those affidavits specifically address the contention in this motion for recusal. I believe everybody, except maybe one member, was present at last month's hearing. I watched that hearing. Mr. Martin was present. Mr. Powell was present at that hearing. At the very beginning of that hearing, as tonight was stated, the board members were asked to please state any known conflicts, any communications that anybody has had with the parties in this matter. Mr. Fagg did state that on 2 occasions in that resuscitation that identifying Mr. Martin as the other party. And why is that important, okay? That preconception, putting out there, identifying Mr. Martin as the other party, is a preconceived motion of impartiality in this hearing. The board, as you all know, you took your oath, is an impartial decision maker. You're not the city. You are not the planning department. You are here tonight and charged and took an oath to make a fair and impartial decision based on evidence presented to you. Based on Mr. Fagg's statements identifying Mr. Martin as the other party, we moved to have him recused from voting in the hearing, the appeal hearing in front of us tonight. I've also handed up, and you can review this in making this decision and during your discussions, it's Knight versus Higgs. And it does go through and discuss the consequences of not recusing a board member who has a impartiality in this process. So in this case, the court did state that it was a due process violation to allow that board member to vote on the matters when there was evidence of preconceived impartiality on part of that board member. This is a Court of Appeals case in North Carolina. This decision that you guys make on this motion is appealable to be appealed to the Superior Court in this county. And based upon Mr. Fagg's statements, based upon the affidavits in front of you, based upon the inherent duty to provide GHM Investments with a fair and impartial hearing through this process, we would move to have him recused from voting in this appeal hearing.
What I would do is, I think that I would ask city staff if they have a response to that, and then I might ask Mr. Fagg if he has a response to that.
Drew, do you have a response to that?
Move on, just commandeer the mic.
You're fine.
So in response to that, I think we've had this sort of concern come up previously. Staff, based on our conversations with each of you independently over the last 2 years that I've served you, when we've had these sort of situations come up, we haven't made a recommendation, and I won't make a recommendation one way or another tonight. I would ask you to consider Mr. Fagg's reasoning for the comments that he made. I do believe it was an intent to kind of provide some clarity based on communications that he had heard and received, and perhaps the language that Mr. Martin and GHM are the other party is being speculated on a little bit to have pointed them out in some way that's derogatory. I feel that it was just his way of saying they are the appellate individuals. But I would leave that up to Mr. Fagg to address personally. Staff doesn't make a recommendation either way. Thank you.
Thank you, Drew.
Okay, this is kind of surprising, but I feel like that I can make a, based on all the information that I hear tonight or would hear tonight, that I can make a, decision, not against anyone or whatever, but just go strictly with the evidence that's presented from both sides tonight.
board?
Okay. As I understand it, the request was for Mr. Fagg to recuse himself, and my understanding is that he's elected not to. Were you requesting a vote of the board on this issue?
If the board will, I don't have the ability to make a motion, obviously. But if the board sees fit, the board can see fit to motion and take a vote on the issue before you.
We need to take a vote. Take a vote? I think we need to take a vote. Okay.
So I'm good, or
Take a-
I need to
I think we need
leave?
to take a vote.
I have a question. I guess this goes to the attorney. I'm counting the number of people here now. We have a total of 7. And without Mr. Fagg, we could have a tie, theoretically. Is that a correct statement in this matter? Without Mr. Fagg, it would be a tie vote. Is that correct? Possibly.
So it's true that you would only have 6 members left. My understanding of the statute is a majority vote would be required. A majority of the members would be required. So whether Mr. Fagg is voting tonight or not, I take that back. I think that if he's recused, then we'd only be looking at a majority of 6, but yeah, potentially you could have a tie vote.
And as such, if you're talking a majority, since you have 6 people, tie vote, the only way for a motion to go for or against would be for it to be 4-2 if he were recused. Is that a correct statement?
I think you would need 4 members, whether you have 4 members voting in favor of whatever you decide to do, whether you have 7 or 6.
Yeah. One further question. If Mr. Fagg does not recuse himself, or if the board does not, what are the possible implications out of the results of our discussion and subsequent votes this evening?
Ms. Bragg has indicated that there is a Court of Appeals opinion that I haven't reviewed that opinion. I don't have it in front of me. I think that you all have to decide for yourselves whether the evidence that's presented to you suggests that there is a bias. And if, obviously, if the board were to make a decision that is biased, then it would be subject to appeal. So I think you've got to decide for yourselves whether the information you've seen indicates that there's bias.
Mr. Fagg? So we need to vote on that. Have a recuse, or would you recuse yourself from this?
You best recuse though.
I think we need to vote.
He needs to say if he's going to recuse or not.
Yeah.
I think that's the first thing that needs to be addressed. If you wish to, or if you wish not to, either way, that will let the board know how they would need to move.
I honestly think, again, that I can sit here and listen to all the evidence and make a decision based on what I hear tonight, and not based on anything in the past or whatever the comments that I made at the last Board of Adjustments meeting. But that's up to the session, up to the board here. If y'all want me to be, if you want to recuse me, then that's fine with me. I'll accept whatever y'all decide.
I think they decided caution.
All right, can I,
We'll be right back in a second.
you want to go ahead and make a motion?
I thought we had to vote.
You have to make a motion first.
Oh, okay.
That's what you want to.
No, I was having a discussion first. See what
Okay.
people thought.
We're discussing. All right, so can we get a motion? Will someone move?
I'll make a motion to recuse him. Is that what you want me to do?
Are you making the motion to have Mr. Fagg recused from the vote?
Yes.
Okay. Now we need a second.
Otherwise, we'll be here again.
Okay. So there's a second. All right. Any further discussion? Hearing none? All right. Can we get a vote? All in favor? Any opposers? All right. Motion carried.
Are you ready for me to proceed? My next motion is a motion to dismiss, and this is a motion to dismiss both of the notice of violations in front of you guys tonight. So there was a little bit, I'd say, of discussion of this on the last meeting and why it was continued, but there has been a blatant due process violation on the part of the city. There are specific requirements for a quasi-judicial hearing that all parties must follow. As everybody knows, your due process rights are a constitutionally protected right that everybody is entitled to, including my client. The statute that is relevant, it's behind tab 14 in your packet tonight. And I'm gonna read from two different provisions. The first it's on page 6 of those statutes in the packet.
What number, I'm sorry?
I'm sorry, it's tab 14, and then begins on page 6, and it's 160D-405, subsection E. Record of decision. The official who made the decision shall transmit to the board all documents and exhibits constituting the record upon which the decision appealed from is taken. The official shall also provide a copy of the record to the appellant and to the owner of the property that is subject to the appeal if the appellant is not the owner. Shall is a very important word in that provision. Next, on page 7, it's part of 160D-406, subsection C, administrative materials. The administrator or staff to the board shall transmit to the board all applications, reports, written materials relevant to the matter being considered. The administrative materials may be distributed to the parties of the board prior to the hearing if at the same time they are distributed to the board, a copy is also provided to the appellant or applicant and to the landowner. These materials become part of the hearing record. When Ms. Bigelow distributed those materials to you all on June 12th, that became a part of the hearing record at that time. That cannot be cured. That due process violation cannot be, the bell cannot be unrung, I think is the phrase I told my client, and he reiterated in that hearing when he made his own motion to dismiss. This is ex parte communication. Let me give you an example. If my client was charged with a criminal offense and the district attorney sends all their evidence by email to the judge deciding the case a week before, to look at all this evidence, have all these preconceived notions, and have this information beforehand. Not only is it in direct violation of two statutes that you guys are to govern, but it's also in violation of my client's due process constitutionally protected rights. The case that I handed up also points on this issue as well. The Knight versus Higgs case. And just briefly in summary, if you look at page 2 of the head notes, and then it is page 7 and 8 of the opinion. But if this is appealed to Superior Court, the Superior Court is going to review if my client's due process rights were violated. And in reviewing the decision by a board sitting as a quasi-judicial body, a Superior Court acts as an appellate court. The scope of the review includes reviewing the record for errors in law, ensuring that procedures specified by law in both statute and ordinance are followed, and ensuring the appropriate due process rights of a petitioner are protected, including the right to offer evidence, cross-examine witnesses, and inspect documents, ensuring decisions by the board are supported by competent material, substantial evidence, and ensuring the decisions are not arbitrary or capricious. Two things here are important. Ensuring that the procedures specified by law in both statute and ordinance are followed, and ensuring appropriate due process rights of a petitioner are protected. Both of those prongs are going to be issues in front of a superior court that I allege to you all are going to be issues that the court is going to find are in violation of the fair due process hearing in front of us today. Again, this bell cannot be unrung. What Ms. Bigelow submitted to you all was not simply a timeline, okay? There's information in there, and you guys have had the packet, but there's information in there on page 5 of the packet, an entire paragraph discrediting Mr. Martin, stating that he has expressed dissatisfaction with the new ordinance. All of this information is irrelevant to the facts of this case, to the facts as it has there been a violation to a zoning ordinance. This is all background information to discredit and attack his reputation, who is the owner of GHM Investments. This was before you guys now, 6 weeks prior to this hearing. This bell cannot be unrung. As stated in Mr. Martin's affidavit that is also provided to you, the timing of, even if they attempted to cure the violation, okay, is troublesome, okay? Ms. Bigelow testified, and it's in this affidavit, and you guys were, the 6 of you who were present, recall under oath that the city never follows this statute. The city never gives the other party also a copy of these documents. The city is blatantly violating every single property owner's due process right. That's the standard in front of the city prior to us getting involved in this case. That cannot be tolerated. That cannot be overlooked. Mr. McLeod, the attorney at the time on June 17th, stated that the day before the hearing, Wednesday, around 4 o'clock, this was discovered. At that time, they could have sent me the documents. They did not send me the documents. They did not call me. The next morning comes around. They could have sent me the documents. They did not send me the documents. They called me and said, oh, we have an issue here. It's a due process violation. We can't go forward tonight. And that's why I did not drive 2 hours last month to be here. What was said during that hearing, Ms. Bigelow said, yes, I'll get them the production of documents the next day. The following day on Thursday, I didn't get the documents. The following Friday morning, I didn't have the documents. I believe, and it's in a email that I can share, but it was at Friday, June 19th at 1:43 p.m. Finally do I receive a copy of the documents. And she admits in this email that these are the documents that were shared last Friday at 10:40 a.m. This did not become a priority to cure, even if it was curable, which we allege is not curable. They have admitted, the city has admitted time and time again, their default process is to violate property owners' rights. Whether it's Mr. Martin's right, Mr. Hinkle's rights, anybody here tonight, if you've had a hearing in the last year or two, those rights have been violated. This cannot be tolerated anymore. This is a due process violation, and it requires dismissal of both of the violations in front of the board tonight.
Yes, I'm sorry. Yes, true.
Sorry, I'm going to steal your microphone again. Yes, you said you had questions or comment from me?
Yeah, in regards to, I'm sorry, I was asking, did we ask questions at this point? It was a lot of information to take in. So do we have any question, any remarks from you as far as what she?
Yes.
was
Yes. So
stating? Yes.
as Ms. Bragg has indicated, I did in fact fail to send those documents. As I was trained in my position and as my predecessor and predecessors before me did, I followed our internal policy. I was not aware of that statutory language. To rectify going forward, we have amended our internal policy to ensure that this does not happen. So you either will get everything along with the applicant or appellate party, or you won't get it prior to, and we'll present everything at the meeting. I think I indicated that last month as well. And there was an error in what I said last month. To my knowledge, we had not been sending that. After speaking with some of my staff, we actually have been sending those documents to the property owners and to the applicants. She does not handle Board of Adjustment. I handle Board of Adjustment. And this is the first Board of Adjustment we've had in quite a while. So I missed it. It's on me for that. But all of the other quasi-judicial proceedings that we have been doing for special use permits and other things, variances of that nature that she handles the paperwork for, she being the city planner Claudia Moore in conjunction with Robin Yount, our customer service representative, they have been sending those packets out in alignment with the statute. It's just this one item I was unaware, since I do handle typically the things for Board of Adjustment that rise to this level. So we have been doing that in the past. It was an error on my part based on how I was trained to do the process.
Thank you, Drew.
Yeah.
Any questions for Drew?
May I add one?
Yes, ma'am.
And I just want to, I acknowledge the mistake. I appreciate the honesty. But again, that does not cure or make justification for a due process violation. If I was pulled over tonight and something went wrong with the procedure and the officer made a mistake because he was training, that does not relieve the liability of the due process violation. So I appreciate the honesty. I appreciate the mistake being acknowledged, but unfortunately, it's something that it can't be alleviated and it does require dismissal. And the court does also explain that in the court case that I've handed up to you.
Thank you, Ms. Clark.
Y'all have a question for me?
Questions for the attorney?
Do we discuss this?
So, go ahead.
If you do not have a question for Mr. Wyatt, there's one other thing that I would like to mention that's been brought to my attention.
Absolutely.
And it may be part of what he was going to say. So there have been conversations that I've both been partial to and impartial to, where I was out of the office and unable to attend. But it seems that we have engaged in conversations with our legal counsel, being Mr. McLeod and Mr. Wyatt, in regard to the issue of the bell not being unrung. I haven't read the case law that they have referred to in these conversations, but there does appear to be case law where once tabled and the documents are received by all parties and it is heard again, since there was no evidence heard last time, that this can remedy the violation of due process. That would be for you to decide and you to consider if our efforts substantiated a cure of the violation. But those efforts have been made, and our legal counsel for the city of Reidsville does feel that our efforts would substantiate a cure.
Let me speak to that quickly. When Ms. Bigelow referred to our attorneys, so I'm here tonight just as Mr. McLeod was last month as your attorney. We're not here to advocate for planning staff. We're here to give you advice. My understanding is that Mr. McLeod last month recommended continuance of this matter in order to...
I don't know if he recommended,
No,
but
he didn't make a
he said we had two choices.
Two choices.
Yeah.
We could continue or we could vote to dismiss.
Okay. And what my understanding, what's being requested is not a dismissal of the appeal. You don't want to dismiss the appeal that
No, I'm asking
you're asking
that
to go back and dismiss the original violation.
I'm asking that the violations be dismissed and the appeal be ruled in our favor based on the due process violation that cannot be cured. And
so I'll tell you that there is case law, Mr. McLeod and I have looked at subsequently, where there are procedural errors that affect a decision made by a board, and it goes up to the Superior Court with these procedural errors. What the Superior Court does, that they don't say, okay, well then we have to rule substantively in favor of the appellant. What they do is remand it back to the board for another proceeding like this. So I think that what this board did last month in deciding to get the information to the appellant and reschedule for a second proceeding is what a superior court would probably do if you had voted on it last week and this had to be appealed. So my opinion is that it was cured by having by rescheduling the proceeding and providing the information to the appellant's counsel. So I mean, Ms. Bragg is correct. I'm sure this is an issue that if for whatever reason this ends up before a superior court, it's certainly an issue that they would raise. But I think the precedent is that the superior court believed that a proceeding was affected by bias. That the remedy is not to. The remedy would just be to remand back to this board for another proceeding that's not affected by bias. So I think that's what this board accomplished last month by getting the information to GHM's attorney and rescheduling the proceeding. But it's for you to decide whether this proceeding is affected by bias that it can proceed.
And I would distinguish just slightly, if I may, of it's more than just the procedural error, but also what was contained in the communications that was shared and that you guys were privy to, and I don't know when you read them, but you could have read them as soon as Friday. And it was more than a timeline. It was more than, photos of what it is. But there's in there, personal attacks on how this property owner is non-compliant, doesn't want to follow the rules, is dissatisfied with the city, when that's absolutely not anywhere near the truth. And if this proceeds past the motion to dismiss, that you will see of the efforts that he's taken to come into compliance. So I think there's going to be some issues. We certainly will raise them on appeal. That I have been instructed to do that.
Ms. Bragg, can I have a question regarding the remarks that you said was kind of irrelevant to this?
Right.
Can you tell me what page? I'm sorry, because it's been
the page 5. Do you have the packet in front of you?
I do have a page.
Ms. Bigelow's packet, page 5.
Okay.
There's that second paragraph, and it goes back into the discussing of the zoning ordinance and then repeatedly discussing the proposal of the ordinance for amendment with city council. You guys are probably most likely where Mr. Martin sits on city council, right?
Yes.
Mr. Martin expressed his dissatisfaction on numerous occasions. He told them he was not going to leave a tree buffer. Let's see, he's publicly stated to staff that he did not want the new clear cutting standards to apply retroactively. All of this information, I understand the board providing you guys a packet with facts of the issues. Here's the ordinance, here's this property, here's a timeline, here's my zoning, officer. That is all irrelevant to this. That is a personal attack on him, and to sway you guys to think he's doesn't want to follow the rules, doesn't want to follow the ordinances, and is here to cause trouble and publicly state that he's not going to do this. And that's a quote that's in there.
And I can speak to that language since I wrote it as well. If you feel
Yes, ma'am.
you need. So can I actually read this? Can I have this?
Oh, you can read it.
Yeah, I'm not going to take it from you, don't worry. So the quote about his stating that he is not going to leave the buffer, we do have the individual who can testify under oath that he said that to here tonight. If you would like to have that witness called when we get to that point, he's more than happy to come up here, take the oath and attest to that language. It is relevant because during the process in which we were beginning to cite these things for the violation and removal of the buffer, that comment was made. So it is relevant to show intent to remove the buffer regardless of avenues for remediation with staff. That's why that was included. It's not a personal attack on him. Mr. Martin, it is a fact that it was stated to staff, and it is relevant in making the argument or proving the point that he had an opportunity to fix it, and it was indicated that he was not going to take an opportunity to fix it. Some of these other things are actually recorded in the minutes of the city council meeting, so they are factual. They're not personal attacks either. They are recorded factually from the minutes of the city council meeting from April 14th, 2026, where Mr. Martin indicated at staff's suggestion to council that perhaps we make this retroactive and alleviate both Mr. Martin and other individuals who had active clear-cutting violations, alleviate them of those violations with a more relaxed policy and allow them to continue to work. And it was stated in the record that he did not want that policy to be made retroactive. He wanted his date in Superior Court. So these are not personal attacks. This is a recount of facts in the record as they exist already, and based on witness testimony who is here to testify should you need under oath.
And so what I would caution the board is, what I heard was that it was a forecast of evidence. It's not evidence yet because you haven't heard that testimony yet. And obviously you're to make your decision tonight based on evidence in the record, including testimony and exhibits that will be presented tonight, and not based on arguments that might be made by either side that end up not being supported.
And as with all the staff memos or reports that we provide, it's more of a narrative of my perspective. It's not the evidence that I have to present to you tonight, which you still haven't heard any of.
I just have a question. I don't know if it's for the question is, it's saying that some of these statements were made during city council. That's public.
Correct.
That has already been disseminated prior to the communication that we're going to receive from you.
Correct. Yep,
So
that was public.
That information is already in existence.
It was public. Yep. It wasn't something that I fabricated or had
I guess I'm just making more of the point that would not be the first time the information was given. Would be from you. Perhaps if we had watched the city council or been in attendance in city council, the information would have been provided at that time.
Made public, yes, to anyone available.
I've got a couple of questions.
For me?
Actually, no.
I'm happy to stand.
No, I don't think they're for you.
Okay.
Maybe the second one is potentially.
I'll wait.
First one is up to the whether or not is there case law supporting the fact that this is considered remediation? Do you know of any case law that would support the fact that?
It sounds to me like there are two different issues, and one is whether the fact that information was given to the board ahead of giving it to the appellant was a procedural violation that means that this case can never go forward. And my answer to that is there is case law that says that procedural errors that impact a board of adjustment hearing can be cured by scheduling a new hearing, and that's what happened.
Okay.
So then the second question, I think, or the second suggestion is that this material was so incriminating or biased that it poisoned the well. You all have to decide that
decision.
whether what the information in front of you is something that poisoned the whale, or whether it's whether you're able to base your decision on the actual evidence that you hear tonight.
Part B to that particular question. Is there, from your end, is there a case law to support?
I have not read the case that Mr. Wyatt's referencing. As an officer of a court is how we call each other. I'm not going to tell you that he's being dishonest with you. I have no reason to think he is. But I have not read that, so I'm not going to tell you that I'm...
That's fine. I kind of thought that may be the answer. Second, frankly put, if we dismiss this, what happens?
So the violation continues to exist regardless of dismissal. Since our violations are issued on a daily basis from the time of occurrence or the time that it's cited, in effect, we could reissue the violations if it's not remedied. That was the suggestion from Mr. McLeod. I would have to do some research on that to see if that's the method we would even want to go. And of course, we would take guidance from council and city management, executive leadership as to if that's what they want to do. But based on what Mr. McLeod has relayed to me, that would be a possibility to reissue, not from the original date of issuance, starting again from a new date of issuance, and go through all of this again. Because the violation is not in effect gone because this has been dismissed. He's still violating the ordinance.
Has the ordinance been amended since?
Yes.
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 And isn't
It
an
has been.
exemption commercial property?
Commercial property that doesn't abut residential, he abuts residential at this site, and the buffer along the residential strip has been violated. So there would remain a violation. So even if we reissued it, it would be under the new ordinance, but a violation does still exist.
And we'll be back here.
We'll be right back here, yes. I don't know that anybody wants that.
No, I don't.
It seems to me, it seems to me, pardon me, it seems to me that too much of the discussion is related to what should be the substantive outcome of the appeal. It seems to me the procedural question that we hear before this hearing should be whether we should be here at all. And that question, I've told you my opinion, is that it's cured and you're properly here. So what I would suggest is that the procedure being proper, that you go ahead with the hearing, and that Ms. Bragg's argument about certain information being not supported by evidence or bias, if that is the argument, it's something for you to consider in your deliberations. But again, my opinion is that the procedural error is cured. So then the question is what you do about the substance of this claim? You know, do you affirm or deny the notice of violation? And I think that Ms. Bragg's arguments are things that you would consider in your decision of whether to affirm or deny the notice of violation.
We approved that remark.
Let me ask. Drew, may we take a, like a 5-minute break?
We're actually about to address
Oh,
that.
okay.
I think
Thank
we
you.
have a consensus.
For a break?
Yes.
Yes, that
Yes.
would be appropriate.
Okay.
We were discussing something among
Okay,
ourselves too.
thank you.
Yep,
Okay.
I think, what,
We'll do, say 10 minutes.
15 minutes?
15?
That's
Is that
fine.
fine? 15 minutes.
Thank you.
Okay, thank you.
We will reconvene at 7.
All right, it is 7:22. We will now continue our Board of Adjustment meeting. So at this time, I'm gonna, thank you, we have heard the motion for, I guess, dismissal from Ms. Bragg. So at this time, is there a motion to dismiss?
So moved.
Madam Chairman, I'll second that motion.
It has been moved and it's been second that we dismiss the, was that the violation? Make sure I'm saying it right. The,
The violation?
Appeal.
the appeal. Mhm. All right. Any discussion? Hearing none, be ready for the vote. All in favor? Opposers have the same right. Hearing none, motion carried. All right.
This is dismissed.
Appeal has been dismissed. Is that correct?
Clarify for the record.
Is that right?
I saw your.
So I want to clarify, you said
Do that right?
the appeal has been dismissed.
I'm sorry, not, yeah, please. Make sure I'm saying this correctly, I'm sorry.
We're in the affirmation of Ms. Briggs as far as.
You're dismissing
We're
the
just-
notice of violation.
Dismissing
The notice of the violation, yeah. Let the
For the
record,
record, can we vote?
that's right.
Let's revote on that.
Yeah, so let's redo it for the sake of the minutes, absolutely. Okay. Okay.
So you want to make the motion again to dismiss the notice of violation?
You do it, no.
All right, I'll make the motion to dismiss the notice of violation.
Second.
Okay. It has been moved and properly second that we dismiss the notice of violation. Any discussion? Hearing none, if you're ready for the vote, all in favor?
Just before we vote, just
Okay.
my understanding is that we may be back at this again. You know, that was my understanding.
All right. Yeah, everybody's understanding? Okay. All right. If you're ready for the vote, all in favor, raise your right hand. All right. Any opposers? At the same right? Hearing none, motion carried. All right. Motion dismissed.
Dismiss the violation.
Violation, the notice of violation has been dismissed.
I would like to let the board know that in rendering the decision, we do need the individuals who rendered the decision to dismiss to write your decision out so that we may provide it to the appellate party. So you'll need to justify why in your written summary.
Right.
And if you want to provide those pieces to staff, we're more than happy to help you put all that together, but we are obligated to give it to them.
It has to be, as the statute says, it has to be a written decision.
Yep, so you'll be providing your written decision to staff, and we can get it to them.
That's on an individual basis, is that correct?
That is just a group, just like,
That's a group.
any other jury.
Decision you would make.
You know, yeah.
Whatever decision you made tonight, even if a hearing went to the end, you would still have a decision to make in writing.
Yep, so it will need to be written. Those of you who are opposed, you can also write an opposing opinion that can be provided, but since this was majority to dismiss, those of you who contributed to that vote will need to get together and write your reasoning out based on what you heard tonight.
And they will follow up with?
You will need to follow up with me as soon as possible. We have to get it to them expeditiously. So as soon as you can get that written, I need to provide it to them for the record. Do you have a deadline that works best?
I don't have a deadline. I would just caution, I think it's the decision of the board and not to collaborate with the city.
Right, no.
Okay.
We're not here to tell you what to write. You write it, you can get it notarized, provide it to us, and we'll provide it.
That would be sufficient.
We can put it on city letterhead for you if you want, but we'll provide it to them.
Does the board have an attorney?
I'm the attorney for the board.
Shouldn't you be writing that?
So, I was a little confused too about your board attorney doesn't prepare orders.
No. In the past, this has come written from the board members.
I'm going to be honest with you, I've served 8 years on this board, and at no point have we had to provide any kind of written statement like that.
Well, the last time they heard a appeal case was in 2014. So if you weren't on the board in 2014, that's the last time this would have been done.
The statute does direct instructions.
That is straight from the statute. I'm trying to fine tune my statutory reading.
That's fine. I mean, we want to follow proper procedure.
Correct. So you as the entity that decided, that those of you who decided tonight to dismiss will need to write that statement based on the facts and findings that you perceived from the presentations that were provided from both Ms. Bragg and myself.
And that's a joint statement, right? It's not individual board.
Yeah, I mean, you don't need an individual. Do it jointly as the board. And then again, the two of you who either abstained or did not vote in favor, you can also have a, opinion that you can write and present. And that way it's in the record that 4 voted this way and 2 voted this way, and that's why.
Okay.
He is our attorney. Is there guidance there for those that may need that?
I think the statute requires the decision to be reduced to writing. Other boards that I have worked with in the past that there has been an order, sort of a consolidated order presented to the board at the subsequent meeting where they have the opportunity then to amend it when they get together as a group. I'm not familiar with this process where the board prepares the attorney without an attorney being in, prepares the order without an attorney being in the loop.
I think they have the right to have you involved.
Yeah, you can
I don't want the collaboration to be with the
No,
city.
staff
It was
doesn't need-
proposed that they could, a couple comments ago were that they could send things in and she could help them put it all together. So-
Well, what I suggest is that you get information to me, I'll prepare a draft order and that I'll circulate with you to be voted on and approved at the next meeting of this board.
Yeah.
That would be greatly appreciated.
Yeah, that would be.
And maybe you should circulate your comments through the chairman and have the chairman present them all to me at once.
And to my participation, I'll just give you letterhead. So it's on formal Reidsville documentation, because you don't have your own individual board letterhead. So once you get it all worked out with him and everything signed and ready to be sent, we'll just put it on letterhead for you.
Thank you.
If this is really the first time that you've done this in 12 years, then I think that should be an acceptable process.
It'll be a new process for everybody.
Just make it. Y'all acceptable? Is that acceptable to y'all?
Yes, sir.
Okay. All right. Is that acceptable to you, Brooke?
Oh, yes, yeah.
Mr. White? Is that acceptable to you?
I proposed it, so yeah.
I'm just making sure we're clear there.
Sure.
Making sure we're all on the same page. Madam Chairman.
Yeah, we're in our board of,
Unless we have anything else to discuss.
we do. Well, we just have member comments, thank you, Ms.
Thank you.
Thank you. Board of Adjustment member comments? Anything to share? If not, can I get a motion to adjourn the Board of Adjustment?
Second.
All right. All in favor? All right. Okay. Yes,
Sorry. Motion to open the Board of
Okay.
Adjustment meeting back up.
Motion to open the Board of Adjustment meeting back up.
There's a question. What time frame do you want our documentation?
No, we said as soon as possible, so let's say at least by, what's today? Wednesday, so you want to say by Monday? That give you enough time? Yes, by Monday the 20th? Okay. Email it to me and then okay. All right.
I'll make a motion that we adjourn now.
Oh, wait a minute, we got, I think we're reopening.
He just
Motion to reopen.
Just tell me when.
And then made the motion to adjourn. I did that as well.
So you gotta get.
I think they, hold on a second. I think she told us to.
It's fine with me if you want to say that. I don't think it should be necessary.
We just, wanted to make one point as staff. Since this has hence been dismissed, in the evidence that we didn't get to present, there are some inclinations about development approval for the site. The dismissal of this NOV stops the NOV proceedings. It does not remedy any failures to obtain permits or site plan approval, which staff does not feel that they have, based on the evidence we have, that you now will not be presented. So this is just a dismissal of the violation, not an approval granted by this board for them to begin developing, constructing anything on the site.
That's correct.
Okay, just making that clear. I just wanted
I just want to
to
put on the record too that this
Yeah.
is the consistent, inappropriate comments at inappropriate time. This is the consistent inappropriate at this time. We're still giving more information of why he should still be in. I just want this on the record, along with the city's comment that this is, no, you all are well aware, but this is what my client's dealing with.
Duly noted.
Let me put on the record that Ms. Bigelow asked me before speaking whether that was appropriate information. I told her to go ahead, so if you want to blame somebody, blame your attorney.
Okay.
It's helpful and duly noted. All right. All right. Dismiss? I think we're good. Okay, we second. We're gonna vote? All in favor? All right. Board of Adjustment meeting dismissed. All right. Thank you all. Have a good evening.